The real danger here is that you're letting the public see one point of view, one slice of information that we know from reports from the FBI is extremely misleading by its omissions. That would be like having a trial end after the prosecution presents its case and let the jury decide based on the prosecution evidence.
That is former Watergate Special Prosecutor Jill Wine-Banks saying the memo released by House Republicans only tells one side of the story. GOP lawmakers behind the memo claim it proves that Special Counsel Robert Mueller's investigation is based on an improper act. And that act would be relying on the Christopher Steele dossier, which was funded by the DNC. But whether there was an illegal action in place is another story. With me now to answer our questions surrounding this memo is MSNBC legal analyst Danny Cevallos. Danny, great to have you here this morning. This memo argues that surveillance of Carter Page should never have been sought out by the Department of Justice and that the FISA warrant should not have been granted. So if these allegations are correct, was an actual crime committed?
The memo is a noble statement of the goals of FISA and the FISA courts. It's just not legally accurate. Here's why. The memo alleges that the FISA warrant application included biased information and it also omitted information that was important. And the answer to that is, yeah, that happens every day in not only FISA courts, but in regular search warrants alone. The omission of facts isn't always fatal to a search warrant application. And at the same time, a potential informant's bias, bias is an essential part of the search warrant process. Confidential informants routinely are biased in favor of themselves. They're basically people who are giving up information that's helpful to their own criminal case, that's damaging to a suspect or a target or a criminal defendant. That's the essence of the confidential informant. So search warrants and FISA warrants have always contained biased information. They've always featured informants who are paid. They've always omitted facts because there's no requirement to include every favorable exculpatory fact to a suspect or a target. So the memo states a noble goal for search warrants. And as a criminal defense attorney, it is a noble idea that these courts should protect citizens' rights. The practical reality is that the FISA court does not protect these rights. Even regular criminal courts do not protect these rights because applications for warrants are ex parte, which means one-sided, and in camera, which means secret. They're, by their very nature, biased.
Okay, and this memo claims that the DOJ concealed information from the FISA court, including Steele's personal views of the president. Is this relevant information that should have been disclosed?
Legally, no. Morally, maybe it should have been disclosed. Politically, maybe. But legally, the fact that an informant is paid, the fact that the informant is biased, will not alone invalidate a FISA warrant or any warrant. That bias can rise to a certain level in a particular case that it should have been included in the application. But the mere fact that an informant is paid, the mere fact that that there's bias, political or otherwise, or even that they have a financial motive, is not fatal to a warrant application. It never has been, and it isn't going to start now. That being said, this is, again, the memo states an optimistic and idealistic view of the way the search warrant process and the FISA process should be. It's just not the statutory reality.
And focusing on Mueller's investigation, there's no legal precedent for an indictment of a president, only a pair of Justice Department legal opinions saying it is not a viable option. The 2000 opinion concluded that the indictment or criminal prosecution of a sitting president would constitutionally undermine the capacity of the executive branch to perform its constitutionality assigned functions. So does this mean that Mueller can not legally indict the president without first going to the Supreme Court, or does it mean that he shouldn't?
Reasonable academic minds disagree on this. If I were a judge, my view is that the sitting president cannot be indicted, first, because he is the unitary executive, and therefore he's the only person in the government that if you arrest him, you essentially arrest an entire branch of the government, the executive branch. Secondly, the language of the Constitution provides, and I'm paraphrasing, that the president must first be impeached, then removed, and then he can be prosecuted. And I think the implication there is that he cannot be prosecuted until he is impeached and then removed. So therefore, he is immune while in office. However, very, very reasonable academic minds have concluded the opposite, and it's equally tenable. After all, if one of them were a judge, then they may reach a different conclusion.
Danny Cevallos, thank you so much for being here this morning. It's amazing how we're making FISA and indictments like normal household words these days. Great to have you here.